Right, well, I welcome members to the 19th meeting in 2012 of the Subordinate Legislation Committee, and as usual I'd ask members to turn off mobile phones. Item 1 is a declaration of interests. I welcome Hansala Malik to the first meeting of this committee. In accordance with Section 3 of the Code of Conduct, I ask him to declare any relevant interest, please.
And thank you very much, Chair. It's a pleasure to be here, and I have no interest to declare at this meeting.
Thank you.
Thank you very much.
Thanks very much. That brings us to agenda item 2, which are instruments subject to affirmative procedure. No points have been raised by our legal advisors on the Property Factors Scotland Act 2011 Modification Order 2012 draft, nor on the Population Statistics Act 1938 Modifications Scotland Order 2012 draft, nor on the Criminal Justice and Licensing Scotland Act 2010 Incidental Provisions Order 2012 draft. Is the committee content with these instruments, please? We are, thank you. This takes us straight to agenda item 3, instruments subject to negative procedure. We begin with Blue Tongue Scotland Order 2012, SSI 2012-199. There is a drafting error in the instrument in that it does not make clear the Scottish Government's intention that the definitions of the terms protection zone and surveillance zone in Article 2 of the order are not to apply for the purposes of interpretation of the term restricted zone in Article 19.4 of the order. As a result, it is not clear that the requirement to notify the movement of animals under Article 19 applies to animals previously located in zones declared to be affected by blue tongue which are outside Scotland. Therefore, does the committee agree to draw the instrument to the Parliament's attention under the general reporting ground because it contains a drafting error? Comments at this stage? Hansala.
Thank you very much, Chair. Yeah, I would like to draw just comment on the draft itself. The Scottish Parliament is answerable to the European Parliament in terms of timing and clarity, and I think clarity is very important. Cross-border issues need clarity at all times and need to be considered very carefully, and therefore I think it's absolutely essential that drafts that come in front of the Scottish Parliament are clear in terms of cross-border responsibilities, and therefore I totally agree that it really needs to be indicated and drawn out for that clarity to take place.
Scott?
Thank you. I too am unhappy about this instrument. I think it's poor practice to rely on possible interpretation of courts to create policy, as it appears that the government's response to questions asked by this committee is depending on that. I don't think that that is sensible, and given that we're starting from a clean sheet of paper, I think particularly if people may be held criminally liable as a result, I don't think that they should have to go to court necessarily to prove their innocence or otherwise. And I think the government have not made a good job at drafting this piece of legislation. Perhaps less importantly, but also importantly, is the poorly definition of a period of midge activity.
Because I'm not sure you're on the right. Is that the right one? Yeah. It is. I'm sorry. In which case, my error. Apologies. I thought we were in another one.
Thank you, Nigel. Is the period of midge activity, which I think lacks definition because midges can and do bite animals when they wouldn't necessarily bite humans. Humans will go to great lengths and by nature and habit avoid being bitten, and therefore they might not be aware of midge activity in animals without a great deal of thought about it, and therefore I think it should have a clearer definition. The midge period can extend into September, October, November, particularly in cattle sheds, because declaring an interest, which I should have done at the outset as a farmer, I have seen midge activity for myself in the autumn and the late autumn, when you certainly wouldn't expect to be bitten by midges as someone in the countryside, as a farmer or as a worker of animals. So I don't know if at that point the midges are biting the animals, because the animals don't say, but certainly by and large they don't bite humans at that time, but they are certainly there or thereabouts among the animals. So I think it's needs clearer definition without wishing to labour the point.
Can I pick up James Dornan, please?
I just want to clarify. I thought that what this definition was doing was giving the flexibility for those who know if the animals are being bitten, not all the time, but you know what I mean, and being able to deal with it then. Because if what you're saying is that you have a definitive period, which is a period of midge activity, and you say let's stop it in the middle of September. By the way, can I just point out that I'm surprised I'm having this discussion, but that then they bite in October. I mean, what if we're not given this flexibility that we're doing here? Are we not having to lay down a specific time? And it may well be that, as you already pointed out, John, that the midges are biting after that.
Mike?
I take your point, but I still have concerns about it. I don't know that it's clear enough, but I think that the more fundamental point is the previous point I made.
I would agree with that.
I think we're probably all surprised we're having a discussion about when midges bite, but that's just the nature of some of the things that come before us. Can I bring Mike McKenzie?
Yeah, I mean, I think there are various different interpretations of what's meant by this, and you know, it's a disappointingly subjective phrase. You know, I'm not at all sure I've been bitten by midges much, you know, more than I care to remember. But what is midge activity is something that affects different people, even different human beings differently. Some people they seem to avoid like the plague, others they bite, prolifically. So I think given that this is could give rise to possible criminal prosecution, that's a hopelessly inadequate phrase and definition.
Okay, I think I then really need to say, clearly this discussion is on the record and there will be people who will be listening and note what we have to say. Do we as a committee actually want to report that particular comment, that we're not convinced that that phrase is good enough, and maybe I need a little bit of advice on this, but maybe it can be reported on the general ground that it's insufficiently precise, or is that unhelpfully vague, or I'm not quite sure what terms you'd want us to use. Mind you, I think one of the things that does come out of the discussion is it'd be very difficult to be precise, so we need to be practical about all this. But clearly there's a general feeling that maybe it's not as well drafted as it might be, and there also, I guess, has to be a thought that maybe it is as well drafted as it could be, and maybe it is just going to be vague. Chick?
I mean, the response itself, you know, would be as well putting a sign up outside of a barn door saying midges keep out. I mean, it depends on, as it says, there are so many different factors. I'm really saying that somebody should go to jail or what have you, because the temperature has changed as it is doing, the whole climate change, wind changes. I mean, it's just, yeah, change the phrase.
Okay, I'm not sure whether they will be able to change the phrase, which is why I think we just need to be slightly careful about this. Would the committee be content then that we report that phrase as well as the point about where a restricted zone might be, on the basis that we're not entirely convinced it's as well drafted as it might be? If I can use those terms without worrying about precisely what the report will say. I get the impression the committee would be comfortable with that. Right, thank you. Okay. Right, just returning to my thoughts and my script, does the committee also consider it unfortunate that the Scottish Government has not considered it necessary to correct that error about protected zones, either now or at the next available opportunity? And do we as a committee now call on the Scottish Government to do so? I think general feeling we'd like the Government to revisit the issues.
And emphasize this more strongly, that clarity is absolutely critical at this point, and I think it's important that that's reflected in our comment.
Yep, thank you. Turning now to the Energy Performance of Buildings Scotland Amendment number 2, Regulations 2012 SSI 2012-208. There's a drafting error in Regulation 9A, which the Scottish Government has undertaken to amend at the next opportunity. Regulation 9A inserts all building units in Regulation 7 of the Principal 2008 regulations after buildings in what it says at both places, whereas it's plainly intended to insert it in 3 places. Therefore, does the committee agree to draw this instrument to the Parliament's attention on the general reporting ground because it contains a drafting error? Jacob.
Question. In the recommended action, it says when the next opportunity arises. Who defines when the next opportunity arises? And if it's impacting legislation, why aren't they doing it now?
How would? Okay, let me try. I think the answer is they'll define when the next opportunity, because they're going to make the next opportunity. Why aren't they doing it now? Because it is a significant amount of work to produce another instrument again. And I think their argument will generally be, it is a patent error. Everybody does know what it means. And nobody is going to jail as a result. Anybody wish? I think that would be the answer. And I think if we're not going to imagine that every...
It's like the rerun of last year, perhaps they won't make drafting errors. We say we want it done and done as quickly as you can, and give us a date when it's going to be done by.
Well, I'm sure we could ask the government when it thinks the next opportunity will arise, and I'm sure they will note your comment.
Chair, I think it's not an unreasonable request to be advised when it can be done. I mean, the fact that if we're taking the trouble to point out to the government that there is an error that needs to be fixed, I think this idea about when they have the opportunity is quite vague, and I think we maybe want to press the point to say that we would appreciate to be informed when it's actually done, and that will perhaps focus their minds in actually doing it rather than sitting on it.
I'm just being reminded that we do check up on these things in our annual report, and we do produce statistics on them, but that is different from asking the government when it thinks the next available opportunity might arise, which I suggest would be a reasonable request. John.
And in terms of a united cross-party approach to this, I would just add my voice in support of that.
So maybe we'd like the government next time not just to say at the next available opportunity, but at the next available opportunity, which we anticipate will be, whatever they come up with.
I also think that good law should not be exercised by whether somebody goes to jail or not as a consequence of the drafting error.
I think we're unanimous on that, Jacob. Are we content, nonetheless, to draw this instrument to the Parliament's attention on the general reporting ground because it contains an error? We are. Thank you. Turning now to the Conservation, Natural Habitats, etc. Amendment Scotland Regulations 2012, SSI 2012-228. There has been a failure to lay the instrument at least 28 days before it came into force, as required by Section 28.2 of the Interpretation and Legislative Reform Scotland Act 2010. The committee may wish to recognise that for policy reasons it may have been imperative to have the amendments made by this instrument and the Conservation of Habitats and Species Amendment regulations brought into force by a certain date as part of a coordinated response to infraction proceedings against the UK. The committee recognises that not having completed the preparation of the regulations prior to the summer recess, a failure to comply with Section 28.2 of the relevant Act became inevitable. In its consideration of the failure to comply with Section 28.2, the committee is not concerned with the contents of the negotiations with the Commission, which concern issues of policy and which the committee understands are sensitive. Rather, the committee would wish to be reassured that the timetable for responding to infraction proceedings, which have been ongoing since 2006, was planned so as to respect the parliamentary procedures for laying and bringing into force all instruments necessary across the UK. The committee expects all administrations across the United Kingdom to endeavour to respect the different legislative procedures which apply where at all possible. The Scottish Government's response has not supplied that reassurance to the committee. It is not clear whether the need to legislate over the summer recess was unavoidable as a result of factors beyond the control of the responsible authorities within the United Kingdom, or as a result of a failure to take proper account of the respective legislative procedures. As the instrument was not laid at least 28 days before it came into force, as required by Section 822 of the Interpretation and Legislative Reform Scotland Act 2010, does the committee agree to draw the instrument to the Parliament's attention under reporting ground J. I wonder whether members have any other comments to make.
I'm very happy with the report. It's quite clear in what we're saying. I also appreciate the fact that the time is critical as well. And I made a comment earlier on in regards to our responsibility to the European Union in terms of time. And that just reflects that on that. So that is important. And I think that we need to guard against it in the future in terms of making sure that we do things stimulously, so we're not putting the Scottish Parliament at risk of being undermined or fined in any way. And I think this is the sort of thing that we need to be guarded of in the future.
Thank you. John?
I would support, I think, that view. Essentially, I'm not reassured that every effort has been made to stick to and respect the 28-day rule. I'd leave it at that.
Thank you.
Surely we'll have that information once the response comes back from the government. Is that not what we were asking for? Sorry, we'll make the point that we want a reassurance that they did everything they could. So.
Yes, I think we're in a position where we've had the government's response to the questions, and I think that's all now history. Clearly, we can now make the point that we weren't as reassured as we might have been.
Fair point, fair point.
Quite simply, there's nothing in there that I've read which says, well, they actually tried to do it to fit in with our rules. Quite how much panic there was elsewhere and why that panic arose is not obvious. Maybe they don't want to tell us, but I think we have not got the reassurance that we wanted. There is also a drafting error in Regulation 4, inserting Regulation 3A4 of the Conservation, Natural Habitats, etc. Regulations 1994. That regulation should specifically apply the duty in Section 3A1 to Sections 23A, 23B, 23C and 24 of the Hill Farming Act 1946, but does not do so. Instead, it applies the general duty specifically to Sections 23 and 25 of the Act, which was not what was intended. Therefore, does the committee agree to draw this instrument to the Parliament's attention on the general reporting ground because it contains a drafting error? Thank you. At the same time, does the committee welcome the Scottish Government has undertaken to lay an amendment to correct this error in due course? Does the committee also welcome that the Scottish Government has indicated there are good arguments in favour of consolidating the Conservation, Natural Habitats, etc. Regulations 1994 in relation to Scotland, and will do so as soon as is practicable? Which I think we would see as a step in the right direction. No points have been raised by the legal advisers on the Building Scotland Amendment Regulations 2012, SSI 2012-209, the Green Deal Acknowledgement Scotland Regulations 2012, SSI 2012-214, the Charities Restricted Funds Reorganisation Scotland Regulations 2012, SSI 2012-219, nor on the Charities Reorganisation Scotland Amendment Regulations 2012, SSI 2012-220. Is the committee content with these instruments, please? We are, thank you. Turning now to agenda item 4, instruments not subject to any parliamentary procedure. No points have been raised by our legal advisers on the annual close time permitted periods of fishing, River Dee, Aberdeenshire Salmon Fisheries District, Order 2012, SSI 2012-210, nor on the Public Services Reform Amendment, Public Services Reform Scotland Act 2010, Commencement Number 6, Order 2012, SSI 2012-218, nor on the Act of Subordinate Sheriff Court Rules, Miscellaneous Amendments Number 2, 2012, SSI 2012-221. Is the committee content with these instruments? Yeah. Agenda item 5, the Freedom of Information Amendment Scotland Bill. The bill confers two separate powers to make subordinate legislation upon Scottish ministers. The first, in Section 4 of the bill, amends the order-making powers set out at Section 59 of the 2002 Act. This power is subject to affirmative procedure. The second delegated power allows Scottish ministers to appoint a day on which the provisions in the bill come into force. Orders made under this power only require to be laid before Parliament. Are we agreed to report to the Parliament that A, we are content with the delegation of power in section 4 and that it is subject to affirmative procedure, and B, that we are content with the delegation of power in section 7 and that it is not subject to any parliamentary procedure? We are. Thank you very much. I think that brings us to the end of the agenda. Our next meeting will be held next Tuesday, the 11th of September. And I close this meeting.